Hi, welcome back to Gumshoe Poos. I've been reading a complaint by a John Doe, stating that he used to work in Macys when he was violently pinned down, made to get on his knees. I don't sure what exactly happened, but Mr. Combs, Puff Daddy, assaulted him. Macys basically fired this person just not long after. And today I feel that this person has come forward because basically they were stating that Combs couldn't possibly have assaulted this person based on him being male. But we know that there's been so many complaints against Mr. Combs, violating people around him in all aspects. I do feel that people around him are accountable, and I feel that no amount of talking on channels like Vlad and all that will make me feel any different, you know? So we'll proceed with reading the plaintiff's complaint, okay? Memorandum of Law in opposition. Defendant Macys, motion to dismiss. Plaintiff John Doe, by and through his undersigned counsel of Busby Law Firm, hereby files this memorandum of law in opposition to defendants Macys Incorporated. Now let's remember that Macys Incorporated also, before Abercrombie, was Macys. So it's the same type of, maybe this was like a sacrificial thing for the company to work with Combs. He has to assault a person, and by that he's got their signature, if you like. I feel that this is the type of shit that goes on in these companies, It's a power flex, isn't it, with Combs? We know he's deprived and evil. We know he doesn't care. He will do what is necessary for the higher-ups. That's why he's in prison. Preliminary statement. Sorry, I've not got my glasses still. This action seeks relief for a brutal sexual assault carried out by defendant Sean Combs in 2008 in a Macys stockroom in New York City. The allegations contained in the complaint, when taken, is true and drawing reasonable into reference, therefrom indicates that Macys conspired with and enabled Combs to commit a crime of violence motivated by gender. At the time of the assault, plaintiff was an advisor for Echo, the popular hip-hop clothing brand, rival to Combs' clothing brand Sean John. In and around May 2008, while working for Echo on location at Macys. So this is a rival company for Combs, and this person, this plaintiff, works for Echo as a rival company, yeah? On location at Macys, right? Flagship store in Herald Square. Plaintiff encountered Combs and multiple bodyguards in Macys' stockroom. One of the men hit the plaintiff around the base of the neck, and forced him to his hands and knees. Surrounded and armed by bodyguards, Combs stepped forward and orally raped the plaintiff while making demeaning comments directed at the plaintiff. After finishing this shocking and deprived assault, Combs and his bodyguards calmly gathered up Sean John apparel and went back on to the Macys retail floor as if nothing happened. Plaintiff immediately reported the sexual assault to Macys security, but Macys ignored the report and took no action against Combs. Rather unconscionably cruel fashion, Macys CEO Terry Lundgren successfully lobbied Echo to terminate plaintiff's employment. Why? Because Macys had just signed a multi-million-dollar deal with Sean John, and Macys had to protect Combs and with value of the deal. Plaintiff report of the assault also appears to have been destroyed and otherwise purged from Macys records. To complete the whitewashing of Combs' criminal acts against the plaintiff on Macys' property. It is reasonable to infer that Macys' was well aware of Combs' violent, sadistic predilections before the time of the assault. All right, and it certainly was immediately after the assault. And by acting to cover up Combs' sexual assault, Macys effectively adopted a violation of the Victims of Gender-Motivated Violence Protection Law, the VGMVPL, as a commercial strategy. Disgusting. So basically, the rival company who was working at Macys' store of Sean John, that's what he was. It's so pathetic. It's so pathetic and so Combs. I can believe it. These facts demonstrate a likelihood that Macys will be found liable for enabling and participating in or conspiring in the commission of a crime of violence motivated by gender, CNYC Admin Code Amiga 10-1104. Macys sets forth 3 arguments in support of dismissal, all of which fail. First, Macys argues the VGMVPL cannot apply retroactively against corporate defendants because the original VGMVPL applied only to an individual, even though in 2022 the amendment to the VGMVPL expanded the scope to any party. As is set forth herein, the plain language of the 2022 amendment to the VGMVPL, the legislative intent of the statute and the case law supports retroactive application of the VGMVPL. That's the first argument against the law they employ at their company was amended to mean a party, so it could be someone who works contractually for another company who works in Macys. Second, Macys argues plaintiff's complaint fails to plead sufficient facts to show Combs' acts were due, at least in part, to animus based on the victim's gender. CNYC Admin Code Amiga 10-1103. According to Macys' plaintiff's own allegations, establish that Combs engaged in violence, including sexual violence against men and both women, and therefore plaintiff's own allegations thus establish that Mr. Combs preyed on victims regardless of gender. See Memorandum of Law of Daniel S. Kotler's memo, page 8, but the fact that Combs violently assaulted people of both genders does not somehow exempt him from the VGMVPL. Plaintiff alleges that Combs assaulted males in order to show dominance, as happened here. Further case law holds that sexual assault itself is prima facie evidence in gender animus. Macys' second ground, therefore, also fails. Third, Macys contends plaintiff's allegations as to Macys are conclusionary and conclusionary. I can't say it. Okay, sorry. I've done this for a while. And that in order to be held liable, there must be allegations as to some sort of prior involvement and setup, as between Combs and Macys in relation to the plaintiff's sexual assault. See Kotler memo, page 11. Macys is unsupported by the text of the VG-MVPL, the scope of which in any party to commit, directs, enables and participates in or conspires in the commission of a crime of violence motivated by gender, by pressuring ECHO to terminate plaintiff and cover up Combs' assault so as to secure profits from its multi-million-dollar deal with Combs' clothing line, Sean John. Macys acted as Combs' accomplice and substantially assisted Combs in relation to plaintiff's sexual assault. Defendant summary, judgment denied. At minimum, Macys' behaviour at the time and immediately following the assault gave rise to reasonable inference that Macys knew of Combs' predilections, and certainly show that Macys was prepared to ignore violent sexual assaults in order to maintain Combs as a source of revenue for it. I'm just a footnote on what I'm saying about Diddy's company as a whole. In 2006, Roger Bonds joined Diddy as a head of security driver. He must have been around this time. Because he would have processed through to be his security guard at the time. And as he stated, Roger Bonds, is that there weren't many artists paying health insurance and the whole shebang at the time. 50 Cent was one, and Puff Daddy, that's all. So he felt, he gets people working for him for these, small perks, but they're big things to deal with. Like, you end up wrapped up in conspiracy charges because he's acting this way around people who will cover his back for him, for these wage slips. Christina Kokorum is one, she worked at the time for him. She worked just after 2008, I think. She worked for him for 8 years too. Under Rule 8, it must be an 8-year hitch thing with him. Under Rule 8, a complaint must contain a short, plain statement of the claim showing that the pleader is entitled to relief. To survive a motion to dismiss, a plaintiff must allege only enough facts to state the claim to relief that is plausible on its face. Dell Article Corp. versus Twombly, 550 US, 55-4, 57, 2007. So that law came into place. I don't know the law of America, I'm afraid. I'm sorry. I'll read it out so you can look it up if you wish. When deciding a motion to dismiss the pursuant rule of 12b-6, its appropriate inquiry is not whether a plaintiff is likely to prevail, but whether the plaintiff is entitled to offer evidence to support his claims. Paul Volek versus Johnson US, applicant Lexus 12600 -5, 2 big D circ June 13th, 2008, Therefore, in considering the defendant motion to dismiss, the court must accept the rule all of the factual allegations in the complaint and draw all inference in the plaintiff's favour. Rowland versus Henneman 517 F 3D 140 142, 2D 2008, Further, the court task is merely to assess the legal feasibility of the complaint, not to assay the weight of evidence which might be offered in support thereof. Counterstatement of the relevant facts. On October 14th, 2024, the plaintiff filed its complaint against Sean Combs and various corporate defendants, including a moving defendant, Macys. Now, that's Abercrombie, who, I can't remember his name, but he was a really old fella and he was raping employees and all kinds of stuff. And it's not strange that Combs is in this realm. I don't think Combs knew at the time that what he was doing was a big part of a bigger network. I feel that Macys as a brand is pretty suspect, considering that it relates to another person who's charged with racketeering and trafficking. The claims set forth in the complaint arose from Combs' sexual assault of the plaintiff in 2008 while in the stockroom of Macys' flagship store in Herald Square in Manhattan. At the time of the assault, the plaintiff was working as an advisor for Echo Company Clothing, a rival of Combs' clothing line, Sean John. After entering the Macys stockroom, plaintiff was hit, forced to the ground, surrounded by armed bodyguards of Combs, and then sexually assaulted by Combs. Plaintiff alleges Combs orally raped the plaintiff and made derogatory comments like, "You like that white boy." After he was finished, Combs gathered Sean John merchandise from the stockroom and passed it out to the crowd outside as if nothing happened. I mean, the statement, "You like that white boy," there's two things there. One, he's a boy. The other is he's white. So that goes against their law, right? Their law to protect gender-motivated violence. And I feel this will be settled out of court because as the brand is, it's a strong brand, and these department stores are getting annihilated now. They're going off the grid into internet selling online rather than being at a store. That sort of where now you won't be able to find who's in charge of all these little people like Diddy. You know, I do think there's a bigger net there. But I think Macys as a brand is a very suspect brand. This is twice this company has been mentioned in racketeering. You know. Plaintiff immediately reported the sexual assault to Macys, but his report was ignored. Shortly after, Macys stopped letting the plaintiff into the store. Macys CEO Terry Lungan later pressured Echo to fire the plaintiff because Macys had just signed a multi-million-dollar deal with Combs' clothing brand, Sean John Clothing. Echo complied and evicted the plaintiff from his company paid apartments. Oh, God. So he lost his apartment as well. That was paid for by the company. The plaintiff is informed and believes that the report of the assault was destroyed and otherwise purged by Macys records. Argument. A. Macys' argument regarding the application of the VGMVPL law is unsupported and must be denied. The MVPL establishes a private right of action and civil remedy for victims of gender-motivated violence, such as domestic violence and rape. Section 10-1102 of the VGMVPL declares the intent to fill the void left by the Supreme Court by providing a broad private right of action and remedies to redress injuries resulting from gender-motivated violence. The predicate for invoking the Act is the commission of a crime of violence motivated by gender, as defined as Section 10-1103. The crime must have been committed because of gender and due, at least in part, to an animus based of victim's gender. Not only his gender, but the fact that he was white. It's a dominant thing. Clearly, it's a dominant thing. The Appellate Division First Department has held that allegations of rape and sexual assault are in and of themselves sufficient to allege animus on the basis of gender under the VGMVPL. See Breast versus Haggis at 180 AD 3D 8394. First Department of 2019, without consent, sexual assault is, in brackets, a violation of victim bodily autonomy and an expression of the perpetrator's contempt of that autonomy. Coerced sexual activity is dehumanizing and fear-inducing. Malice or ill will based on gender is apparent from the alleged commission of the act itself. How sad. Couldn't put it better. Here Macys argues in part that the plaintiff claims should be dismissed because the VGMVPL applies only to individuals, given that Section 10-11 of 04 of the VGMVPL, entitled Civil Cause of Action, states only that any person claiming to be injured by an individual who commits a crime of violence motivated by gender has cause of action against such individual. However, the current text of the Amiga 10-1104 provides that any person claiming to be injured by a party who commits, directs, enables, or participates in, or conspires in the commission of a crime of violence motivated by gender has a cause of action against such party. Therefore, the VGMVPL clearly provides for a cause of action against not just the individual perpetrators, but also an entity that is alleged to have facilitated the gender-based crime. Macys also argues that the VGMVPL cannot apply retroactively against the corporate defendants, and that the plaintiff's claims regarding sexual abuse occurring in 2008 should therefore be dismissed. In support of its arguments, defendants relies almost exclusively on Doe v. Combs 23 VC CV 10 628 JGLC 24 WL 49867 044 SDNY December 5th, 2004 in brackets, wherein the court held that 2022 amendment to the VG-MVPL, which expanded the scope of liability to apply to any party, cannot be applied retroactively against corporate defendants because the original VG-VPL applied only to any individual. However, neither... I see. So it's amended it to mean a party as well as an individual, like Sean Combs and Macys, you know, where it wasn't there for before. However, neither the Second Circuit nor the New York Court of Appeals has endorsed this reading, so it doesn't exist, and it hasn't been stated in law. The VGMVPL, though, is at best merely persuasive authority. Further, there is authority in other high-profile cases, as least implicitly, that retroactively doesn't apply to corporate defendants. See Vice versus Labrado, 2024, New York, Lexus, 25 337.7. Support of CT, New York's CNTY, November of 26, 2024, brackets, in case involving MVPL claims against Harvey Weinstein and various corporate defendants, which arose from alleged rape of 2001, in court denied corporate defendants a motion to dismiss. Oh my. As originally enacted, the VG-MVPL provided victims of gender-motivated crimes of violence with a cause of action against only the individual who perpetrated the crime. See NYC Code Title 10, Chapter 11, Amiga 10-1104, EFF, December 19th of 2000, in brackets, effective January in 2022. The City of Council amended the Amiga 10-1104 to provide any person claiming to be injured by a party who commits and directs and enables, participates in, or conspires in the commission of a crime against gender-motivated violence as a cause of action against such party. Okay. Amiga 10-11 EFF January 9 of 2024. In the same enactment, the City Council also amended the Amiga 10-1105 entitled Limitations to provide any civil claim or cause of action brought under this chapter is barred because the applicable period of limitations has expired, is hereby revived, and may be commenced not earlier than 6 months after, and not later than 2 years and 6 months after September 2022, The 2022 amendment created a 2-year look-back window for survivors and gender-motivated violence to file lawsuits, regardless of when the assault occurred. Taken together, the two amendments, one, expanded the liability to non-perpetrator defendants where no liability had previously existed, and two, revived cause of action brought under the statute whose limitations period had already expired. Macys' argument is contrary to the VGMVPL's preliminary intention to make it easier, not harder, for the victims of gender-motivated violence to seek civil remedies in court. New York City passed the VGMVPL in light of the void left by the Supreme Court's decision in United States v. Morrison, NYC, Admin Code Omega 8-902. Morrison struck down the federal right of action for victims of gender-motivated violence under the Violence Against Women Act, VAWA, 42 U.S.C. Omega 1398-1, holding that Progress lacked the authority to interact it. 529 U.S. 598 62-7 of 2000. It is fundamental that It is fundamental in interpreting the statute. The court should attempt to effectuate the intent of the legal statute. Caddis versus Jones versus Zimbrati, 2000, New York, slip up for, so many numbers, 3013-5 4 of 2000, WL 34697795 at 1 Sup City, New York, CNTY of April of 9th of 2000. Upholding VGMVPL was intended to apply retroactively, citing Petroleums versus Benevolent Association of City of New York, 42 of NYD 2D 205 to 28 of 1976. The Council intended the VGMVPL to make it easier for victims of gender-motivated violence to seek court remedies, intended in the same when passed of 2022 amendments of the law. See example of City Council HRJ testimony, November 29 of 2021 at 41 testimony in support of Act passage describing sexual abuse in 1993. HRJTR November 29 of 2029 at 12-9-30. There is no timeline in the processing trauma. 131. As victim doesn't have a set time for when they can come forward. Allow the window of justice to be pursued by all victims of gender-motivated violence estates. based on analysis of statutory text and history brackets. Comma, upper brackets. It is clearly that the legislative body intended brackets the VGMVPL to apply retroactively. Caddis versus Jones of 2002, WL of 346977 of 95 at 11. Beyond the plain intent of the VGMVPL as a broad and retroactive statute, there is also the fact that Macys itself is not a primary subject of the VGMVPL claim here. Plaintiff is alleged at Macys, Combs and the Combs defendants conspired to permit Combs to accomplish the sexual assault at issue here. In other words, to violate the VGMVPL, a plaintiff may plead existence of a conspiracy in order to connect the actions of the individual defendants with an actionable underlying tort and establish that those actions were part of a common scheme. Litterus versus Litterus of 25-4, AD 28 of 39-5, of 36, 39, 6, 68-1, NYSD 2D 545, citation omitted. See also Alexander versus Alexander. Macys, as a co-conspirator, cannot escape the potential liability, even if it is correct that it cannot be held primarily liable for the violation of the VGMVPL. A co-conspirator can conspire to commit a tort that the co-conspirator itself could not commit. So he couldn't commit the act itself unless it was at Macys' store. Okay? So that in itself is conspiracy, New York law permits allegations of conspiracy when they serve to enable a plaintiff to connect a defendant with the acts of his co-conspirators, where without it he could not have implicated. First Kruger Industry versus Crow Constra, AD 2D 415 417. First Department of 1958, i.e., when they connect a When they connect a defendant to an or otherwise actionable tort, I'll say that again. When they connect a defendant to otherwise actionable tort, Monsanto versus Electronic Data Systems Corporated 14, 1, AD2D 5145115, 2D Department of 1998, brackets, defendant Combs was himself subject to and violated the VGMVPL. Plaintiff has alleged that Macys conspired, aided, and abetted Combs in committing that violation. It is therefore does not matter at all that Macys itself might not have been subject to the VGMVPL at the time of the events alleged in the complaint. Plaintiffs adequately pleaded gender animus. B. Macys argues plaintiff's complaint fails because Combs engaged in violence against both men and women, and concludes that plaintiff's sexual assault by Combs could not possibly have been motivated by gender. But it's a power thing, it's a power element. He doesn't care who they are, you know. And the fact he was a boy and he was white, it was a power dynamic there. He didn't commit this voluntary. He was forced by him in your company, and this is how you deal with it. It's disgusting. But Macys cites no law that a sexual predator has to choose between genders, and Macys cannot explain why Combs should be exempt from the VGMVPL. I bet you they can't. Simply because he has assaulted people of both genders. There is no such reason why an offender cannot have gender animus against both genders. Macys also argues that Combs disparagingly referred to the plaintiff as Echo, and therefore the assault was a business-related element to the crime, you know? This is what I'm saying. This argument fails as well. You know, this is what he's saying. You know, he says himself, during the assault, Combs also asked plaintiff, "You like that white boy?" Question mark. Comply 41. That's that statement in context indicates animus on that basis of both race and gender. But it isn't an either or choice. Macys cannot explain why only one animus is relevant. It is entirely possible that Combs' assault on the plaintiff was driven by all of gender and race and business animus. Plaintiff pleads that Combs referenced his gender during the assault. The plaintiff pleads that Combs referenced his gender during the assault. Plaintiff also pleads that Combs often assaulted men to show domination over them, i.e. as men. But it does not matter whether Combs made any explicit references to the plaintiff's gender or any other source of animus. The Appellate Division First Department has explicitly held that the allegations of sexual assault are in and of themselves sufficient to allege animus on the basis of gender under the VGMVPL. See Briest vs. Haggis, 180 AD 3D 8394, First Department of 2019. Macys argues that Briest is inapplicable here because Briest involved a hetero assault as opposed to the same-sex assault here. But that is irrelevant because the principle underlying Briest's decision was not gender differences, but rather the violation of the victim's bodily autonomy and the expression of the perpetrator's contempt for that autonomy. Sorry, I feel I've gone back a bit. Coerced sexual activity is dehumanizing, fear-inducing, malice or ill will based on the gender of a parent and from alleged commission of the act itself. ID. It is Combs a coercion of sexual assault, an activity I'll start again. No. That was the violation of the force of the weapons and sufficiently established gender animus, regardless of the fact that he and the plaintiff are both male. Macys' argument is this on this ground fails. C. Plaintiff adequately pleaded that Macys enabled, participated in, or conspired in this abuse with the meaning of VGMVPL. Macys argues that the plaintiff complaint should be dismissed because the plaintiff does not allege any facts giving rise to the plausible claim that Macys enabled and conspired in Combs' assault. Copland Memo, page 11, Macys' basis is argument on Doe and Venture, A36F, Applex 67 and 68, 2D Circ of 2021, wherein the court held that to plead a conspiracy, a plaintiff must provide some factual basis supporting the meeting of the minds, such that defendants entered into agreement, express or tacit to achieve the unlawful end. The VGMVPL provides that any person claiming to be injured by a party who commits, directs, enables, and participates in, or conspires in and commission of the crime of violence motivated by gender has a cause of action against such party. See NYC Municipal Code Title 10, Chapter 11, Mega 10-1104. To plead the claim of conspiracy, the complainant must demonstrate the primary tort, plus following 4 elements. 1. The party's intentional participation in the furtherance of a plan or purpose. 2. An agreement between 2 or more parties. 3. An overt act in furtherance of the agreement. And 4. Resulting in damage or injury. Cohen Bros 181 AD 3D 401 404 First Department of 2020, where, when given the benefit of every favourable inference, it is clear that the complaint contains well-pleaded allegations, satisfying the additional elements to state a claim for conspiracy to commit those underlying torts. First, the plaintiff has alleged facts demonstrating that both Combs and Macys possessed a common purpose, which was to enable Combs to commit sexual assault without repercussion, and intentional participating acts in furtherance of that purpose, satisfying the first element of the conspiracy cause of action. Second, the plaintiff alleged facts from which this court can infer an agreement between Macys and Combs to engage in this common scheme, satisfying the second element. For example, plaintiff has alleged that he reported the sexual assault to Macys, and Macys thereafter pressured Echo executives to fire the plaintiff because Macys had just signed a multi-million-dollar deal with Combs' clothing line, Sean John. Moreover, the plaintiff alleged, upon information and belief, that Macys destroyed or otherwise purge the report of the plaintiff's abuse. Additionally, the plaintiff alleged that Macys actively placed, maintained and/or employed Combs in a position of power and authority, despite the fact that Macys knew, or should have knew, that Combs had a widespread practice of committing assaults and gender-motivated violence, including on the premises owned and/or operated by Macys. Third, the plaintiff has alleged overt acts in furtherance of the aforementioned scheme, such as causing a termination of the plaintiff's employment, causing the plaintiff to lose his company paid apartment, and destroyed records related to the assault. Fourth, the plaintiff has alleged damages he has suffered as a result of underlying tort. Because a plaintiff has pleaded all of the elements necessary to state a claim of civil conspiracy to commit underlying torts, this court should deny Macys' motion to dismiss on this grounds as well. So they're not allowing Macys to dismiss the case. It's going to go ahead. Conclusion. For the reasons stated herein, plaintiff respectively requests that this court deny defendant Macys Incorporated motion to dismiss in its entirety, dated the 30th of January 2025, respectively submitted by the Busby Law Firm. This one is pretty damaging because there is some kind of environment outside the workforce of the house or at Bad Boys Incorporated or any of their grounds. I feel this one is pretty, damning because there's a record in witnesses that come forward, and talk about these things, and there's other people confirming his story as well, because all we hear is case after case after case now. I'm sorry I haven't been online putting these up for a while, but I wanted to get this one on because it's got Macys and it's happened at Macys. I feel it's just generally just getting the word out that we need to, that this is not Sean Combs, just him. This is the people around him, the company around him, the people he did business with, and it's about time that this was exposed. I don't know why it's sort of being kept quiet about these companies involved. Macys is the Abercrombie, it's the same bill, it's the same place, there's a link to other things as well, and it wouldn't surprise me if he had any relationship with the Abercrombie brand as well, but this is what I'm up to at the moment. I'm going to post more as I find them, and I hope this is what helps. Any suggestions are welcome on my comments for content to do. I will be very great if anyone could tell me. It'll be more of this to come. And thank you very much for watching. Please subscribe and like for the algorithm and myself to get out there, because my views are not getting hit, and I appreciate it all. Thanks so much for watching. Bye bye.